Hello, everyone, and welcome to our webinar today on privacy, data security in a globalized world, cross-border issues and trends. I am absolutely thrilled to have with me Bill Roberts. He's the chair of Shipman Goodwin's data privacy practice and is a member of the firm's health law group. He advises healthcare, insurance, and technology and other organizations on data privacy matters, including legal compliance, data breach response, and government investigations. He's got a wide-ranging client base, which I won't go through, and is available on the screen. But I will say he's a certified information privacy professional in the U.S. through the IAPP, is active in numerous states and national privacy law organizations. And I can tell you from my personal experience, Bill is a phenomenal source of information in the area of privacy and data security. And Bill and I first met about a year ago at a meeting talking about this, and we've been very keen on doing a presentation for our respective clients because we're constantly dealing with cross-border issues, and it's good to have that information and source together. I'm Paige Backman. I'm the chair of Aaron Burles' Privacy Data Security Group and the co-chair of the Technology Group. That's the extent that I'm going to go into my bio. You can read it if you'd like. I've got a couple admin things that I need to go through, and then we will get to the heart of this wonderful, hopefully wonderful educational webinar while you eat your lunch. For those who are licensed in the state of New York and Connecticut, there's a course code will be given randomly during today's program. Please enter the course code on the affirmation form, which you may download in the Resource Center, which is at the left side of the screen, and then follow the submission instructions. If there are any issues with downloading it or printing it, please send an email to rsvp@airdburles.com, and we can certainly help you out with that. So just to start this off, we're going to take a quick poll. The question for the poll, just to see that you're not just focused on your food, but actually giving this some attention, and so we understand where you're coming from. If you suffered a data breach or a privacy breach that involved data or personal information in Canada, the United States, and elsewhere, are you comfortable knowing how to respond? So if you could take a second, provide the answer on the screen that pops up, that would be great, and we're going to get started. We're going to start first with an overview of the Canadian privacy laws, and then Bill's going to take us through the U.S. perspective. And at the end, each one of us are going to deal with at the end of each of our presentations, each one of us is going to deal with some scenarios that we typically see. And at the end, we're going to answer some questions that have come in. We do have people from registrants from all over the world. We've got several hundred registrants, so welcome to everybody. And let's proceed. So just to give you an overview of the Canadian privacy laws, I think it's important to note that privacy in Canada is recognized as a quasi-constitutional right. That has implications on how privacy is valued in the Canadian legal system. In the EU, privacy is a constitutional human right. So when we look at the spectrum of how significant privacy is in legislation, you've got EU, which is on the far side of a constitutional right. Then you've got Canada, and Bill will talk about where US is on that spectrum. In Canada, we have a federal regime, which is equally strong legislation at federal and provincial levels. So one is not going to supersede the other. We also have common law, recognition of torts involving privacy. Obviously, we've also got breach of contract. The basis for Canadian privacy law is a concept of personal information. And that's important because the US, Canada, and the EU have slight nuances in terms of what will be protected under what regime. So in Canada, generally speaking, personal information is information that can identify an individual directly or through reasonably available information. Canada currently enjoys what we call adequacy status with the EU under the GDPR and the former EU regs. That's important because when you're dealing with cross-border data flow, the fact that Canada enjoys adequacy status means that we have less hurdles in Canada to jump through to be able to facilitate the processing of personal data from or involving EU residents. I will say that while the damage awards are significantly less than what is typically seen in the U.S. and the EU, of course, Canada is seeing a cottage industry for our class action litigators in the areas of privacy breach litigation and data breach. So let's start with the legislation. Let's take a look. Let's start with the private sector, as most of us are working in that area. We have umbrella legislation with limited sector-specific laws. What that means is we have, that applies to the collection, use, disclosure, and safeguarding of personal information. What that means is Canada, as opposed to dealing with sector-specific privacy laws, which you see a little bit more, and Bill will talk about that in the U.S., Canada has what we call umbrella legislation. So the federal legislation, the Personal Information Protection Electronic Documents Act, or PIPEDA or PIPEDA, and CASL, that will apply across Canada to the extent that there's not a provincial legislation. PIPEDA will apply across Canada to the extent that there isn't provincial legislation. And I can talk a little bit about that in a second. And CASL is Canada's notorious anti-spam legislation, which is world-renowned for its absurdity in terms of its scope and its penalties. There is, if you look at a Venn diagram, there is a part overlap between CASL and privacy laws relating to consent and what form of consent is necessary, and it differs between CASL and PIPEDA. Provincially, we've got private sector legislation in the provinces of Alberta, British Columbia, and Quebec. I always note that Quebec is a civil law jurisdiction as opposed to the rest of Canada, which is common law. Quebec also, the majority of Canadian privacy laws are very similar, including Quebec, but Quebec tends to be more consumer-based, consumer-friendly, and consumer-protective than the rest of Canada. So interpretations can be slightly different in Quebec than the rest of Canada. We also have provinces have health information-based legislation. In Ontario, it's PHIPA. We also have consumer protection legislation at the provincial level. That deals with consent and contracts with individuals. None of the legislation, federal or provincial, will restrict specific sectors or from having legislation that imports higher standards than what's in the umbrella legislation. But Canada is lucky that it has very limited sector-specific legislation governing privacy laws. So it's a bit easier to while there are more organizations and people are subject to privacy laws, it's a bit easier to navigate because you're working through less pieces of legislation. In the public sector, and this is where we've got an interesting issue when we're talking with U.S. cross-border issues. So let's start with some of the easier ones. At the federal level, you've got Privacy Act and Access to Information legislation. And at the provincial level and municipal levels, you've got Freedom of Information and Protection of Personal Information legislation, and the municipal have corresponding Freedom of Information legislation as well. So those are relatively typical legislation that I believe are pretty consistent in the U.S. as well. And Bill's going to jump in if I'm misstating something. This is where, by default, if you're working with governments, public sector in Canada, your information will be publicly accessible on request, but there are exceptions to that default. One exception, which is typically across the board, is on personal information, that those are under only limited circumstances. Personal information may be disclosed to the public, but other information is generally accessible. I want to talk a little bit about public sector access laws in British Columbia and Nova Scotia. Both of them have laws that prohibit, so not just notification requirements, which we see under, let's say, PIPEDA and some Alberta legislation, but the laws in BC and Nova Scotia, when you're dealing with public sector entities, which can be a broad definition, so we have to keep that in mind, they prohibit the disclosure of personal information out of or even accessing personal information from the U.S. or outside of Canada. So when you think about this network world where cloud environments are the norm and data's flowing, data has no regard for borders, this type of law where there's an actual prohibition on disclosing information outside of Canada or even accessing personal information from outside of Canada can cause a lot of issues for organizations working with either government organizations or private sector working with government organizations. There are certain ways to get around it, but the default position is absolutely no-go on storing or accessing information outside of Canada. So let's go through just what is typical in Canada. I'll put this on one slide because the joy of being in Canada where the privacy laws are typically, the private sector privacy laws are typically uniform in their concepts. We can do this. There are obviously some nuances, but generally speaking, it's based on the fair information handling principles, which mean informed consent. Implied or express consent must be obtained for the collection, use, and disclosure of the information. So for each collection, use, and disclosure of the information, you must have informed consent. And whether you can use implied consent or express consent depends on the circumstances. What I will say is that Canada is moving more toward the requirement to have express consent. Historically, we have been relying on passive privacy policies on websites. That is not necessarily the direction where the legislators and the courts are going. They are now looking to more express consents. Consent is dependent on the capacity of the individual. So while we do not have a children-specific privacy law, what we look at is the individual, do they have the capacity to provide informed consent? So you have to take the age of the individual and other capacity indicators to know whether or not it's appropriate to rely on the consent of the individual. You must limit the collection, use, and disclosure of personal information to that which is reasonably necessary. So, for instance, if I'm ordering pizza, it's okay to ask for my address if you're going to deliver pizza to me. It's not okay to ask for my driver's license. Where we see a lot of is U.S. companies that will come into Canada and ask for things like social insurance numbers, or the equivalent of social security numbers, and background checks. Canada is a little bit more restrictive on the ability to ask for that information. You should not be asking for social insurance numbers unless it's necessary for tax purposes. If you do ask for it, it must, at the very minimum, be optional. And there are limits to when you can do background checks on individuals, including employees. The security obligations that organizations must undertake are tied to the sensitivity of the data. And the sensitivity of the data is not just, it is including financial information and health information. Those are by default sensitive. But it can even be passive information or what we would consider non-sensitive information like an email address, depending on the circumstances. So we look at the circumstances. For instance, if you've got an email address that's tied to a sensitive, let's say a subscription to a sensitive political magazine, or in Canada now we have this cannabis sector. If you're someone who is a user of cannabis now, that is potentially, even your email address could be sensitive. As I mentioned, some laws will restrict the location of the personal information. I mentioned BC and Nova Scotia for their public sector. I will also note that Alberta, the province of Alberta, have obligations in terms of notification obligations if you're using service providers in the U.S., and also the obligation to know where that data is stored outside of Canada, which can be we've had a number of issues with companies in Canada that use service providers that are, let's say, a Google-based provider or platform, and Google stores their information on servers around the world. So you really have to turn your mind to where this data is being located. Accountability under Canadian privacy law rests with the primary collector of the personal information, the one who is the organization that's collecting it for their own primary purposes, but it's not solely. So if you're using subcontractors or if you're sharing the data with other people, those other persons can also have claims against them if they fail to act in accordance with privacy laws. There's contractual obligations. They must be bound processors, secondary subcontractors, even affiliates. When I say third parties, under Canadian privacy laws, affiliates are third parties. So you need to have contractual provisions in place with those third parties that limit the use and protection of personal information, as well as audit obligations, and we'll go into that in a little bit. You have obligations to delete or destroy personal information when it's no longer reasonably required. In a few days, just around the corner, so welcome to Canada's breach notification obligations. Breach notification obligations have existed in the province of Alberta for a while. Canada at the federal level are having those introduced as of November 1st. You must report to the OPC, which is the Privacy Commissioner of Canada, as well as possibly individuals when there's a breach of security safeguards. I've gone through on this slide what that means. It's any loss of unauthorized access to or unauthorized disclosure of personal information if it's reasonable to believe that the breach creates a real risk of significant harm. And that's key. Does the breach cause a real risk of significant harm? And that's where we always, and that's similar to the threshold out in Alberta. And that's always where a lot of the discussion is around is, does this breach cause a real risk of significant harm? So we have to look at the context of the breach. And significant harm is widely defined. And as soon as, if you make the determination there's a real risk of significant harm, you will have to notify the Privacy Commissioner and individuals and possibly third-party organizations or government bodies if those third parties are able to mitigate, reduce the risk of harm to the individual affected by the breach. And you must report it as soon as reasonably possible. In the EU, I believe it's 72 hours. We don't have 72 hours, but we do say as soon as reasonably possible. You also must keep records of the breaches, even those that do not create a real risk of significant harm, for 2 years. And you have to provide a copy of that record to the Privacy Commissioner upon request. We're starting to get some fines. They can go up to $100,000. And we do have some movement on a legislative front to bump up the fines of our own Nate Erskine-Smith, who used to work here. So shout out to Nate for introducing this bill. Don't know if it's going to go anywhere, but it's been introduced to put some real teeth behind the damage awards for a breach. As I said, Alberta, there's an existing notification obligation in Alberta, and under health legislation, there's always been breach notification. Now, one of the bigger differences is while we have this wonderful regime of privacy laws in Canada, the teeth to those privacy laws have generally been pretty light. That's a big difference between the GDPR in the EU and the US. Statutory damages are minimal except in limited instances, and individual claims typically run from about $1,000 to $20,000. What that has caused, though, or generated, is an industry for class actions, because even if you have small $2,000, $2,500 claims, you multiply that by a couple thousand people, you now have a real class action that you have to spend a lot of time and money defending. So let's go through two scenarios. The first is, and these are typical scenarios, but there's always, variations of these, and we're happy to work through those with you. The first is we've got a service provider from the U.S. So the service provider in the U.S. wants to provide services to Canadian entity, and that service will involve the processing or collecting of personal information or personal health information within the U.S. So it's a situation where you've got Canadian data, personal information on Canadians that are going to be somehow processed or stored in the U.S. How do we go about doing that? What are the issues? So the first thing we ask is, what's the information at issue? Because there's a difference between, we always ask, is it identifiable information? Because sometimes you just get bits of information that can't reasonably identify the individual, and if that's the case, then we're outside privacy laws. If it does identify the individual, is it health information or non-health information? Because then you go down two generally different paths. You have to know the location of the individual whose information is at issue. So even if you've got an organization in the province of Ontario, if you've got residents or information on individuals in the provinces of Quebec, BC, Alberta, or our Atlantic provinces, you need to deal with the jurisdiction at issue, and you may have multiple pieces of legislation you have to deal with. You ask, is it private sector or public sector? As I said, if you've got public sector and you've got residents in BC or Nova Scotia, then you may have an issue. You may have a bit of a hurdle that you need to jump because of the prohibition on disclosing information outside of Canada. So then we look at, once we have those threshold questions, we look at, are we dealing with PIPA, PIPA, which is the BC Alberta legislation, the Quebec Act, or health legislation, and then we go down the analysis. And an odd thing, which I find is an effort by the legislators to ease up on some of the business, is this distinction of a disclosure versus a transfer or use. And typically, and this is important for personal health information legislation for the most part, but also under private sector, not health related. If this is somebody who's acting as an agent for you and simply providing services to you, there's a tend to look at that as more of a use or a transfer and not a disclosure. And the difference there is, if it's a disclosure, we need consent for that. If it's simply a use or a transfer, then as long as the concept of what's happening has already been consented to by the individual, then we don't have to get secondary consents for that. So what we look at from that distinction is, are you just providing services to the organization in Canada, or are you able to use that information for your own purposes? And if it's for your own purposes, then it's, even in part, then we look at that as a disclosure. If it's simply acting as a service provider for the Canadian organization, then we look at that more as a use, as an agent for us, and we don't look for secondary consent requirements. As I mentioned, you have to look at whether there are restrictions. That's typically under BC, Nova Scotia public sector, but Alberta has its own requirements for notification obligations and information. So you want to make sure you're on side with that. And then let's say that we've jumped through these hoops and we're okay. What happens next? Then we have to enter into contractual obligations with the third party, even if it's an affiliate. That is a requirement under all laws. You must have contractual obligations which bind the companies that include restrictions on how you can use the information, i.e. it's just to be used for purposes of fulfilling the obligations under the service agreement. You have obligations to protect the information, safeguard it. There's typically level of security that's imported into those contracts. We deal with indemnification obligations, investigation obligations if there's a breach, who is to control the investigation, who's to control the notification obligations, and of course we look at carve-outs from limitation of liabilities. You've got to look at those clauses quite carefully. Typical limitation of liability clauses will carve out consequential damages, punitive damages, indirect damages. A lot of the damages that an organization will suffer could be construed as indirect damages. And so what you want to make sure is that when you're looking at your limitation of liability clause, that you're keeping in mind the nature of the damages that may be suffered, and make sure that those are carved out. Or conversely, if you're on the other side, you want to make sure that those are capped. So depending on your approach to the contract, those are your important clauses. And again, audit rights. I can't stress this enough. There's a lot of clauses don't have audit rights. We're seeing them more and more. But it's not just enough to have audit rights. You really should exercise those rights, because it's to cover your own back. It's not enough if there's a breach to say, well, I had this right to audit in my contract, check the box there. Did you exercise it? Did you actually look to see if that organization was complying with the obligations that they're supposed to? And it may not take a lot of effort, and it's a pain, but one, it prevents breaches, so you're not into those situations, and two, if there is a breach, it's a good due diligence defense to say, one, we had it in the contract, and two, we exercised that right, and from what we saw, they were compliant, or to the extent they weren't compliant, we made sure that they were compliant. Scenario number 2 is the acquisition of a business. It's a U.S. entity that wants to purchase a Canadian entity, and there's personal information at issue. What's the analysis we tend to go through? Obviously, asset or share or investment, because obviously you've got different liabilities that are going to flow from one to the next. What personal information is at issue? That's a common question throughout all of these analyses. Is it employee or non-employee information? Because in Canada, employees across Canada have different protection. Some have very little protection and some have more protection. Again, jurisdiction of the individuals, not the target, is at issue. And is the personal information the main asset of the transaction? If it is, if it's a significant asset in the transaction, then you may not have the exemptions for business transactions that currently exist under law. Most of the business transaction exemptions which permit the disclosure of information in contemplation of a business deal will have an exemption that says, but this does not apply if really what you're buying is the customer list. If the main asset of the transaction is the personal information, then those exemptions don't apply, which ultimately means you have to go back and get consent of the individuals for the disclosure. We look at restrictions on personal information transfers before the transaction, including on due diligence. And NDAs. Most people, they come and say, well, we have an NDA, we should be good. Well, NDAs don't always are not always appropriate for personal information legislation. They deal more with business information. And some of the more standard carve-outs we see in NDAs are not appropriate for personal information. So we have to look at those. You have to limit the disclosure to that which is reasonably necessary for the purchaser or investor to make the decision. So you can't just, if you're under this business transaction exemption, you can just do a data dump and give them all the information on, let's say, the employees, including the reason for the medical leave, their social insurance numbers. That cannot happen. You have to limit it still to what's reasonably necessary for the transaction. I always recommend that you don't include personal information or in documents or agreements that may be posted publicly. Law firms have gotten into difficulty when, I'm guessing in the middle of the night, filling out a schedule, they just did a data dump. They thought it was terrific. They posted it online, and it had things like social insurance numbers for employees and banking information for customers. That's not okay. So we try to deliver those in separate documents. Reps and warranties are obviously important. Standard precedents now, I think, are up to about 4 to 5 pages, and then you can carve them back if you need to. But what I really can't stress enough is that breaches, unauthorized access or hacking can occur several months before the transaction closes that people are unaware of. So if we look at the Yahoo deal, that became, and Bill can talk more about that, I mean, that's just a great example of where there was an intrusion a great period of time before the deal closed, and people were unaware of it until after, the contracts were signed. So make sure your reps and warranties and survival clauses are appropriate. And of course, there's post-closing restrictions at law on what you can use that information for. So it's not just that I own it, I can do whatever I want. You are still limited to the permissions that were received prior to closing from your target company. And you may have notification obligations. So the deal's closed. Now you have to notify individuals that the information's been transferred to the purchaser. And now I'm going to hand it over to Bill.
Great. Thank you very much, Paige. And now we're going to go to kind of take the flip side of this and talk about what a Canadian business needs to know about privacy laws and risks when operating in the United States, whether it's physically or through the sale of goods. We're going to cover a lot of the same topics that Paige did, and then end with 2 scenarios. To start, I just want to give an overview to address how U.S. privacy law is fundamentally different in structure than Canadian law. Importantly, as and which is quite different as what Paige was discussing, the U.S. lacks any umbrella privacy law. There is no general privacy law on the federal level. The result is a patchwork of federal and state laws Often the requirements are buried in regs or bulletins, notices, attorney general opinions, and otherwise. And the result is that we have a large patchwork of laws, varies tremendously by state, by territory, and how current these laws are often varies tremendously. And because of this, unlike Canada, the U.S. does not enjoy adequacy status under GDPR, which does make transfer of data from the European Union to the United States more difficult than if you were to be transferring that very same data to Canada. We haven't seen any meaningful movement on the federal level to correct this. Now, while I know many of the people on the call may have heard the comments from Tim Cook, the CEO of Apple, yesterday, I believe, speaking in Brussels, where he called for the U.S. to have a GDPR-style law, personally, I don't see that happening for at least 5 years. So I would not hold your breath for waiting for this regime to be changing. So while we haven't seen much movement on the federal level, certain states have been taking leadership roles in expanding privacy laws and in also improving them. The holistic approach is the first one of note was Massachusetts, which adopted a fairly broad data privacy law regarding the protection of data, the development of a privacy and security program. More recently, and which will go into effect in 2020, California adopted its own GDPR-style law. There's also been some sectoral approaches, most notably New York, which about 18 months ago began its cybersecurity requirements for financial institutions, including banks and insurance companies. And then less dramatic, but also important, we have seen states take targeted improvements. Connecticut law clarifies when credit monitoring needs to be provided, which gives some certainty to business. Ohio recently passed some laws to give safe harbor protection to businesses that have a breach and handle the breach well. So we are seeing certain movement, but it's primarily on the state law, which in fact just creates even more of a patchwork. This law, for the Canadians on the call, gives an overview of that patchwork. So when you are looking to do business, you really need to be looking at every single one of these categories and seeing which of these buckets do I fall into. And if I had 6 slides, I would probably be able to fill 6. So don't think this is all of it. It's also important to know who the regulators are, because in the United States, unlike in Canada, there is no Office of Privacy. There's a very large number of agencies that have their fingers in privacy, and it's important to know this because a lot of privacy law is sub-regulatory guidance, which you may miss when you're just looking at statutes. The only one I wanted to highlight here is the Federal Trade Commission, which was set up to govern unfair trade practices, but has become the de facto privacy regulator on the federal level. And who should know them? Everyone, because you do want to be looking at, if you're doing business in the United States and it involves the collection or use of personal data, you do want to be making sure you're doing so in a quote-unquote fair manner. Some of the others are more targeted: Health and Human Services for healthcare providers and health insurers, for HIPAA, Securities and Exchange Commission for public companies, the FCC for telemarketers, and a few others. On the state level, we see something similar where attorneys general tend to be the de facto regulator. Now, this varies tremendously by state. Some states have very advanced attorney general privacy departments. Others take a more relaxed approach. But in every state, we do see the AGs as the primary privacy regulator. After those, you tend to see more of a sector specific, and this isn't for every state. So not every state health department cares about privacy. Not every state education department has any privacy laws, but there are certain things in most states you do want to be aware of. So enforcement trends, sort of like the laws, the enforcement trends tend to be inconsistent as well. Some U.S. privacy laws are vigorously enforced with substantial penalties. Think HIPAA. Others tend to be lower priority. So, for example, in healthcare, there's a law called the Part 2 Reg, which applies to privacy for substance abuse providers. While it's a very strict law that's been around a long time, we don't see the same level of enforcement with that law or the same degree of penalties as we do with other healthcare privacy laws. However, on the whole, we are seeing more enforcement actions, higher penalties, and the public becoming more willing to voice their concerns regarding privacy. And it's important as well to note that enforcement isn't limited in the U.S. to penalties or fines. Very often a company may suffer a breach and have no penalty or fine, but instead may lose a state contract, may lose a license to operate a business. These can actually be more devastating to a company than a fine or penalty. So given all the laws in play, I just wanted to point out a few key risk areas. Number one certainly is breaches. And we see that with Yahoo. We saw that recently with Anthem, a $16 million penalty. Sectors, healthcare and insurance, tend to be probably the two areas where there's most action. On the federal level, the FTC unfair trade practices. This gets into collecting data from minors, collecting people's data via websites, via apps, customer portals, sort of taking data which are in a manner which you're not putting folks on notice of and not giving them a right to be opting out. Telemarketing is a huge risk area where non-U.S. companies tend to stumble. The U.S. does have a law similar but far less severe, I'll say, than Castle called CAN-SPAM. It's important to be aware of that, though fortunately there's a lot of great guidance from the government on how to comply. But the law I want to highlight here is called the Telephone Consumer Protection Act, known as TCPA. This law has a tremendous amount of guidance. It is often difficult to put into practice, and the penalties for it can be exceptionally large. So that applies whenever you're looking to make robocalls or robo-texts to individuals in the United States. I can't stress enough that if you have some sort of plan to be doing that, you do need to look at the TCPA very, very carefully. And then the last is the financial services in New York State. Litigation, sort of the same as Canada. You know, we haven't seen a tremendous amount of data privacy litigation. There's some big name matters that have been getting a lot of press, but we're not seeing the same degree of class actions or other lawsuits as we see in other types of matters, such as personal injuries or medical devices. However, trends are pointing to more litigation in response to data breaches and data practices. The first is negligence. A few states, including my home state of Connecticut, recently in the past few years are recognizing the right of a data breach subject to sue the data holder that suffered the breach for negligence. So let's say, for example, a breach occurs as the result of, or reasonably as the result of, noncompliance with HIPAA, or in the school context, perhaps FERPA. The courts have held that data breach subject does have standing to be suing you. The reason we haven't seen more of these in the negligence context on the state level is because courts have been extremely reluctant to find harm, to find damages, what you traditionally need to sue someone. Now, while that has tempered litigation on the state level, we are looking at more class actions, just like in Canada on the federal. And I just want to spend a moment talking about the inconsistent laws regarding class actions having standing to be suing in the United States. The Supreme Court had an opportunity to create one national standard. It did not do so. So we currently have certain jurisdictions in the United States, particularly in California, where you don't need to meet the traditional high bar of actually having an injury in fact, some sort of damage in order to be suing. So what we're seeing now is a lot of at least attempts, and some of which have been successful, to bring class actions as the result of a data breach. As these two areas of law develop further, I would expect to see the cost and risk of a data breach and the cost and risk of not complying with U.S. privacy law to increase dramatically. So now we're going to move on to case studies. We're going to do sort of the flip side of the ones which Page did. And the first one is our Canadian service provider. NS Connect, which is a blockbuster cyber mobile app company, fictitious of course, wants to make its product available in the United States. It's read in the New York Times all about the opioid epidemic, and is thinking, you know what, this is a great market for us. Let's take our product and see if we can sell it in the United States. The CFO asks, are there privacy issues? They listened to one of Ann Berlis's webinars and are thinking, should we be thinking about privacy? So we start off with a few items here in terms of what should NS Connect be thinking about. First, you want to look at who are our customers going to be. And they've identified hospitals, home health, substance abuse, employee assistance programs, health insurers, and Medicaid. So quite a mix of public and private healthcare and insurance sector clients. They want to operate in every state and territory from Maine to Guam. Licenses, fortunately, none. Marketing, they're not going to do robocalls, and they're not going to do robotexts, and they're not going to do spam. They're only going to be operating their website. And what the data they expect to get is patient data or member data. So the challenges. Their initial challenge is going to be identifying in that big old patchwork, what are the laws that are going to apply to them, and most importantly, what are the laws that their customers are going to be subject to. And this is a point I want to stress probably more than any other, is that when doing business in the United States, we've seen again and again that both regulators and, more importantly, customers want to see a privacy program designed specific to U.S. law. A great example is a matter we handled where a client was looking to do business in the United States. They had a top-notch, top-of-the-line privacy compliance program. It complied with GDPR, Canadian law, Australian law, laws of various Asian Pacific countries, and it was so much more strict than every single U.S. privacy law put together. They approached a national health insurer in the United States and couldn't even get in the door, because their first question was, we're not even going to speak to you unless you have a HIPAA compliance program. And they said, well, we don't, but our policies are so much more strict than HIPAA. You know, we will report a breach in 72 hours, not 60 days. It didn't matter, because the customers are going to want, if you're looking to sell your product, it's particularly in finance, education, insurance, or healthcare, they're going to want to see a U.S.-specific privacy law, and it also is helpful with regulators should something go wrong, so that you could point to exactly the federal reg that you are complying with and that you have a policy to go with, rather than explaining how the right to amendment under HIPAA, you don't need to worry about that because we have that under GDPR. It really is important that customers, they want to see that specific policy so they could check their own boxes. Now, if you're in this sector, you're looking at fairly straightforward business. They're looking to provide a mobile app. A whole host of privacy and related laws will need to be complied with. We already mentioned HIPAA, which is the National Healthcare Privacy Law. You mentioned looking to contract with Medicaid, which is a state-run public insurance program. Every state has its own contracting requirements. Like Nova Scotia, I believe, Texas, for example, says if you are providing services to our Medicaid population, that data cannot leave the United States. It can't even go to a country which has stronger privacy protections. It must stay in the United States. Other Medicaid programs are much looser. I mentioned substance abuse rules earlier, Part 2. Because one of the customers here is the substance abuse program, and in terms of drug abuse and drug management, you will want to be looking at those as well. And there's a whole other host of requirements, state law requirements, Health and Human Services requirements, FTC requirements, and NIST, the National Institutes of Standard and Technologies. So before NS Connect comes to the United States, before they approach customers, they're going to want to know all of the questions these customers are going to be asking and making sure they could check all of their customers' boxes. Because the goal always should be to go to your customer in the United States and say, you don't have to worry about us. Engaging us, using us as a service provider will not increase your privacy risk. The second case study, Superior Marketing of Thunder Bay purchased the assets of Badger Media of Madison, Wisconsin. One of the items here is that Superior Marketing really wants the data that Badger Media has spent years collecting. They go ahead with the purchase, and only after the closing do they realize that a lot of that data isn't very clean. It's tied up. There's legal restrictions on it. There's contractual restrictions on it. And the CEO is frustrated, of course, and she asked her staff, how could we have avoided this mess? First part, in terms of a privacy strategy, when looking to acquire a U.S.-based business, is to consider privacy as a fundamental aspect of your M&A strategy. First is look at the jurisdictions. What are the states and territories that the target is operating in? What are the technologies? What are the data sets? Meaning, is it healthcare data? Is it financial data, medical records, demographics, driver's history, criminal histories? Who are the data subjects? Are they patients? Are they minors? Are they decedents? The sectors, and also, be aware of any highly regulated industries. So it's very possible in this fact pattern that Badger Media collected some data from hospitals and also some data from the local tire store. Those two data sets will not be treated equally. The tire store data is probably going to be very lightly regulated. The hospital data will be a very different story. You also want to be looking at having a very thoughtful due diligence process. You can't avoid privacy-related risks in an acquisition unless you know where and how the company stores data. That has to be the first question. It's amazing how many times you can go through an acquisition and look at privacy policies and security controls for the data sets you know, but then realize only after close that there's some completely other data set stored in Argentina that you had no idea about. So it sounds obvious, but it's probably where problems arise most often. Privacy policies, the thing's obvious, make sure that they have them and read them, but you want to make sure that they're following them. What are the consumer-facing ones and the internal? Policies are only worth the amount of paper that's on them. So it's not very useful just to have a piece of paper, even as fancy as it can be on a shelf. Security controls. I'm often apprehensive, have lawyers evaluating the technical controls. As much as your lawyers may say they're experts, you don't want to be paying hundreds of dollars an hour for a JD to be looking at your firewalls. But you do want to be looking at the legal sufficiency. Looking at the data profile, how clean is the data, and then looking at integration. How difficult may it be? Contractual protection, these are a lot of the same ones we heard Paige talk about. So I'll just wrap up here quickly with these. Reps and warranties. Did the target have a right to the data? Do they have a right to sell it? Do they have a right to sign it? Indemnification in case of a breach. This is probably like, as Paige mentioned in the Yahoo case, you do all the due diligence in the world only to realize post-close there's a breach. You're going to be on the hook. And also think about risk allocation. What kind of risk are you thinking exists here, and how do you want that to factor into the purchase price? So with that, we're going to leave the remaining time for questions. And we did receive a few questions already, and I'll take the first one. I've learned after working with Paige that probably the most common Canadian concern about doing business in the U.S. Lies with the U.S. Patriot Act, which was an exception for the few folks in the call who may not know. It was a law passed after 9/11, which basically allowed the United States federal government to access any data on any person that it wanted for any reason. I may be being slightly facetious, but in practice, that's really the way it works. And that has been scaled back considerably since 2001. But the specific question is, if a Canadian company were to store its personal data of its customers or patients or members in the United States, does the Patriot Act mean the U.S. government, the federal government, has a greater right to access that data? And the short answer is yes. There's a famous case, Microsoft v. United States, in which the U.S. federal government sought to access data held by Microsoft. It was able to utilize its authority under the Patriot Act and similar laws to access data held in the United States. But some of the data it wanted was held in Ireland. It was not able to access that data because where it's held increases, Ireland needed to follow those policies and increase the protection. So practically speaking, the lesson there is that if you do keep data in the United States, there is an increased exposure of it being accessed by the U.S. government. And then I'll turn that over now to do some other questions.
Okay, there was a great question that came in. Do Canadian rules apply equally to consumers and employees, or are there more or less restrictions, protections for employees? And the response to that is it depends on the jurisdiction and the company and the type of company. So, for instance, federal legislation, PIPEDA, which governs most private sector across Canada with the exception of BC, Alberta, Quebec, within provinces, PIPEDA will only apply to employee information about federally regulated organizations, and that means banks, telcos, that sort of thing. It doesn't apply to employees in what we call provincial or more of the typical type businesses. So what does that mean for you in terms of how to manage that? if you're national, which I believe the person who asked this question is, we typically say because you've got probably employees in BC, Alberta, Quebec, you probably have an employee privacy policy, and that should really just apply just some good practices to your employees across Canada. If you are someone who is, let's say, in Ontario, you are not regulated, you're not a federally regulated organization, then your employees actually do have fewer protections under statute than the consumers may have. There's another question that I thought maybe that came in that I thought could be helpful is, does using a cloud service provider of a U.S.-based company like Microsoft and Amazon within a Canadian region create new exposures to the laws or authorities of the U.S. government? So I think Bill just talked about the Patriot Act. We had a couple questions that were related, and what I would say is, and one made specific reference to AWS. The answer, ones you have to look at, does it create more risk? Yes, because of the Patriot Act, but and other laws as well. But you have to look at the type of data that you have, and there may be, in fact, be prohibitions on you being able to store it in the U.S. For instance, if you've got public sector data mixed in with your other data, you may have some restrictions. I will point out that Amazon has a Canadian server to try to address this issue. They came up. I think it was about 2 years ago when they brought their servers to Canada to try and address some of these jurisdictional issues. Outside of the legal prohibitions, you're going to want to. You are subject to the security. You want to make sure that the contracts that you have in place, not that you're going to be negotiating with Amazon or Google, but just take a look at the contract terms, whoever you're using, cloud provider, and make sure that they tick the boxes for protection and use, and look at their history. Not all cloud servers are the same. Some will store in the U.S., but some will also have they'll have servers around the world, and you really need to know that because there are differences of protection in countries. I mean, the U.S. may have a sectoral base, but overall, I think that their protections are decent. We generally don't have too many issues coming from the U.S., but when you get to other countries where there really is no data protection or very limited enforced, that's where you're going to get a lot of the issues. So keep in mind who your data server is, who your cloud provider is, where they're storing data, what's their history, what's their reputation, and understand that you may need to make some changes if you're not comfortable. And I echo Bill's comment that it should not be a lawyer telling you the security architecture, whether it's appropriate or not. As much as we like and we want to bring in money, there are very few lawyers that are in the position to give that, and we recommend that you get a true IT security person giving you advice on that.
Next question we received in the healthcare context, and the question reads, can you please confirm that no privacy laws in the U.S. apply to Canadian PI or PHI? I would like to confirm, but of course, since I'm a lawyer, it's fairly qualified. Typically, that is correct. U.S. privacy laws would not apply to any Canadian healthcare data or personal data. Though, like with most things, there are exceptions to that general rule. Occasionally, and I can't stress occasionally enough, but there are some non-U.S. healthcare providers who may accept U.S. public insurance, such as Medicare or Medicaid, often associated with military bases, or the public insurance program called TRICARE, which is for which are for active duty military personnel. So, for example, I have worked on matters, for example, in Germany, where the U.S. has a very large military presence. There are providers there who become a TRICARE participating healthcare provider. If you're in that unusual position of actually getting paid for healthcare by Health and Human Services by a state, generally the requirements of that payment will mean that you need to comply with HIPAA or other healthcare privacy law and protect the data in accordance with that law. That's rare, but it does certainly happen. The other aspect is through contract. So, for example, a Canadian company may provide services on behalf of a U.S. health insurance company. It may keep that data in Canada. So while this may not be data of Canadian citizens, it is personal data held in Canada. That company would be what's called a business associate under HIPAA, and therefore would need to comply at least through contract with U.S. privacy law. It is an open question of whether the U.S. government would have authority to bring an enforcement action under HIPAA for a non-U.S. company. I don't believe that that's ever happened. But I think practically speaking, you're not going to win the business unless you have the compliance in place. Thank you very much, Bill. That was terrific. I hope you all enjoyed and took something away from this webinar. We thank you for your attendance. We hope you enjoyed a good lunch while you were listening, and we look forward to seeing you at future webinars. Take care and have a wonderful day.